The court is in a unique position here because I sat through the other trial, which is what has been offered into evidence by the state, the entire trial and evidence from that trial, the wire calls, the recording from the Dolce Vita meeting, the recording from the Matsuri meeting is additional evidence that has been reviewed and by the court today. Also, there's some iCloud texts and depositions that has been presented to the court today. So I have reviewed all the evidence, so I am in a position to make a ruling. The court finds that based on the evidence provided by the state, that the state does meet the standard of proof evident or presumption great that the defendant has committed the 3 charged crimes. Not only is there direct evidence the court finds from the Dolce Vita video and statements made therein, but there's also a wealth of circumstantial evidence against the defendant. Even if a court subsequently finds that there was only circumstantial evidence, I find that the evidence presented by the state certainly rebuts every reasonable hypothesis of innocence. So I find that the first part of the test is met, and proof evident or presumption great standard is met by the state. Secondly, the court will not exercise its discretion to release the defendant due to the nature of the crimes. I find that he is a danger to the community. I additionally find that he is a substantial flight risk based on the evidence that's been presented. Particularly concerning is his statement in the Dolce Vita video about getting to the airport, if there was any evidence, but there is also other evidence that he is a substantial flight risk, and so therefore the court will continue to hold him no bond at this point. Mr. Rashbaum, I acknowledge the difficulties that you have in preparing for trial, and I'm going to assist you in any manner that I can within the confines of what's required at the jail. What I propose is that with what you have detailed to me in your argument today in regards to your client not being able to listen to the wire calls through the MP3, which I had ordered before specifically, the use of the computer in the jail, your limit on attorney's visits and the time that's required for that, and your need to get documentation to the defendant. I think I've identified those particular 4 things. If you could put that in a motion and offer in that motion what you think is a reasonable, or what you're requesting, so that you can have preparation time with your client and review it with the state. I don't think the state's going to have any issues with most of the things that you propose, because I think that they want to move this forward also. I will assist you in any manner whatsoever with contacting who I can within their limited resources at this time, but I think we do need to move it forward, and sometimes it might take an order from the court in order to do that. So put it in a paper motion with the proposed order. Make sure that in that motion whether or not there's any objection to the state, but I've identified those 4 things. If there's any additional ones that you need for your preparation that are reasonable, I think these are reasonable, then also put those in your motion. We'll consider it. I don't think we will need a hearing on this. If we do, then I'll hold that hearing by Zoom so that we can get it done quickly and efficiently.
Thank you, Your Honor.
Okay. Ms. Kappelman, so that we're clear for the record, if you could please prepare a short order that says, for the reasons stated on the record, that the motion for pretrial release is denied, and then that way we have it clear in the record for any further review that's necessary. All right, so the next thing that we have on the docket moving forward is we have a case management in December. If we get this motion and some action from the jail, Then I think at that time we'll have a better indication as to whether or not we'll be ready for trial come February or March. I've been looking at dates for that. The one consideration in March, and I don't think it's for the convenience, it's not for the convenience of the court or really for anybody sitting here, but spring break is in March, and so we have to think about that in terms of getting jurors and whether or not it's going to interfere with those plans. So I think that's later in March, so I was looking at dates possibly end of February, beginning of March. But let's have a better idea. If we don't do it then we're probably looking at April or May, because we can't do it in late March. We're just not going to have the jurors. It's just going to be too much of an inconvenience for them. We're already dealing with enough issues in regards to getting jurors. So let's keep that in mind. And I think we'll have a better idea of where we're headed at that case management so that we can definitely blank out some dates then, either end of February, beginning of March, or if we're heading into April or May. Okay, any discussion in regards to that? Ms. Kappelman?
No, Your Honor.
Anything from the defense, Mr. Rajbaum?
No, Your Honor. I think we'll have a good idea in December.
All right, great. If you can get that motion to me as quickly as possible so we can get moving on these for you, and then we'll be in a position to know come December. All right, Ms. Kappelman, anything else for the court?
No, Your Honor.
Anything from the defense?
No, Your Honor.
All right, thank you both. We'll be in recess.